Okay. This is a meeting of the Government Operations and Health Facilities Subcommittee of the Health and Government Operations Committee. We have 3 bills on our agenda today. We'll be taking them in the following numerical order: House Bill 13, House Bill 182, House Bill 235. House Bill 13, if you could explain the bill and as it is proposed to be amended with, and that is a document that everyone has received. Lindsay?
As introduced, the bill requires that a person be debarred for 5 years from entering into a contract with the state following the issuance of an administrative order by the U.S. Department of Labor that finds the person has violated a federal executive order by engaging in discriminatory hiring practices. I've circulated an amendment to the subcommittee from the sponsor that says rather than mandatory debarment for 5 years, instead, BPW is authorized to debar a person if the person has been found to have committed a violation of state law prohibiting discrimination in employment or has violated the federal executive order prohibiting discriminatory hiring practices. And it also clarifies that the bill is prospective.
Okay, sponsor, do you wish to say anything at this time?
Yeah, thank you, Mr. Chair. Good morning, subcommittee members. So I wanted to thank Mike Johansson for his very thoughtful collaboration in helping us craft this amendment that I think takes the direction that you all were going, but fits it into the existing statute in a very elegant way. And thanks to Lindsay for her work on the amendment as well.
Is there any discussion among the members of the committee about the bill as amended? Delegate Saliga.
Thank you. And I'm assuming the reprint is what you sent around, Lindsay? That's what we're discussing. Okay. Thank you for working on it and answering the many questions I had about the bill. So is it still 5 years or is it up to 5 years?
There's no time period specified now. It would be up to BPW to decide how long the debarment is for.
Okay, and could this be done now? I mean, that was the question I never really felt like I got the answer to. I mean, do we need this bill or can this actually be done now?
It would depend on what it was enterprise rent-a-car that was sort of the impetus of the bill. I don't know specifically what they did. So there are provisions in state law now that if they had violated certain provisions of the labor and employment article, that could have subjected them to debarment, but there are discriminatory hiring practices not covered that if they had done those would not have subjected them to debarment under state law.
Well, and obviously this doesn't pertain to that because it's not looking backwards, it's only looking forward. So
that's true.
You know, this wouldn't even have affected that. So I'm not convinced that we need this. I think any of these practices, of course, you know, no one thinks there should be discriminatory practices. And, you know, I think the BPW could do this now, adjudication on it. So, you know, how does a person or company appeal the decision of BPW?
That would be under the Administrative Procedure Act, under the existing provisions now. That's not changed under the bill.
So
what does that mean?
Circuit court? Would it go to a circuit court?
Yes.
Is that, yeah.
So if a company, let's just explain it to me in nuts and bolts. A company has been found guilty of discriminatory practices that willfully, knowingly violated sub 20, blah, blah, blah. The finding was made by a court. Decision of the court was final, was made in a contested case and not overturned. So then who would take that to the BPW?
The Attorney General's office.
So the AG would take it to the BPW and they would say, we're requesting the BPW debar company X for, what do they just make up a term? Are we defining that, Al? Are we saying, at least a year, up to 5, forever? Like, are you not going to define it?
It is not listed in the bill now. I don't know if in practice, the Attorney General's office suggests a period of debarment. That's not written in state law, but BPW can decide the period of debarment when they're issuing their order.
Okay, debarment's pretty serious. I mean, discrimination's very serious as well. But without some guardrails around what your intentions are, that's our job as lawmakers, to put some guardrails up. So I'd like you to think about that. And then,
But if I may, Lindsay, you're saying that under existing law, that is a decision to be made upon recommendation of the term of the debarment is made upon recommendation of the Attorney General, but a vote of the Board of Public Works.
I don't know if the Attorney General makes a recommendation or not. Is the Attorney General who institutes proceedings to debar a person by filing a complaint with the board, and the board can decide period of debarment. I don't know if in practice the Attorney General says.
Understood. Thank you.
Yeah, we
that's not
missing
specified.
some of that instruction. So then company X says, I'm unsatisfied with this determination. Their recourse is to go to court to have it overturned. Is that correct?
Yes, and that there's also provisions in law for the company to apply for termination of a debarment with the board as well. I doubt that would happen immediately, the same way an appeal would. It would be after some period of time to say debarment should stand anymore.
Okay, thank you. I think we still need some work on this.
Delegate Sample Hughes, followed by Delegate Kaiser.
Thank you, Mr. Chair. And I think some of my questions have been answered that were posed by Delegate Shaliga. But I guess for me, I just wanted to understand. So BPW would have to look at this on a case-by-case issue, or would they be required to come up with parameters of how long, or based on what this company did, this is the area in which they would be disbarred for, or how long they would be? Is that something, or that goes a little too far?
It's a case-by-case decision.
Okay.
Yeah.
Okay. All right. Thank you.
Delegate Kaiser.
Thank you, Mr. Chairman. I wanted to address some of the concerns that Delegate Shalega brought up. If I heard correctly, when you asked, would this apply to enterprise? Obviously, we're being prospective and not going back. And then you were then suggesting, well, then maybe we wouldn't need a law like this. But I guess I saw the opposite conclusion, that we definitely need something like this. That if people hit the threshold of discrimination that impacts the federal rule in Executive Order 11246, or they meet the discriminatory practices based on our state law. And you may not know, but those standards between the two are a little bit different, with a little bit of overlap. So it seems like we do need something, and this law is ensuring that a company that engages in such discrimination would have to be debarred from our contracts. And that, to me, is the values of the state. We've expressed our values as a state of who we value, and that people shouldn't be discriminated. And if we believe that people shouldn't be discriminated against, we should then have consequences. So that would be part of my argument. I think I also heard you say that we need guardrails, but I think a lot of guardrails have been put into this. And as you may not know, I actually spent a lot of time looking at this bill. There are so many reasons that a company could be debarred. It is not just discrimination. There are if you look at the code, there's all the reasons that a company shall be debarred. There's all the reasons why a company may be debarred. So, this could happen for a lot of reasons, and we're just adding one additional one. And instead of the original 5 years, I'm with a lot of people. I didn't like the 5 years because the federal government says in their executive order that if you undo the problem, if you fix it, you can be reinstated. And so while I would have wanted an immediate reinstatement, I think Delegate Carr is looking for something different to have it go to BPW. So BPW can look at the decision and say, you now do abide by state law or you do abide by federal law, and you should now no longer be debarred. So I think, again, we're following the values of our state regarding discrimination, but we're letting companies that fix the problem get back. So I just wanted to address some of those concerns.
And I believe, if I can follow up on what Delegate Kaiser just said, that for under existing law, for certain violations of our civil rights law, a business can be debarred, but they could not be debarred for hiring practices, violation of that provision. And that's what this bill seeks to address. Mr. Johansson.
Thank you, Mr. Chairman, and thank you, members of the subcommittee. Mike Johansson on behalf of Enterprise. I appreciate all the comments and appreciate the sponsors' assistance in listening to our concerns. Obviously, the prospective nature of the bill provides some certainty, not only to my client, which, we are working on an issue at the federal level, it's not resolved yet, but to many other companies that may have had a violation in the past that wouldn't have triggered debarment, but now won't be looked back upon, but will only be considered going forward. Secondly, to answer a couple questions that are actually already addressed in the current law and the way that the new amendment is structured, we're picking up all those same protections that are in the current law. So if you are debarred for a federal violation by the federal government, then Maryland Board of Public Works may also debar you. If the federal agency removes the federal debarment, the Maryland law automatically would lift the state debarment just by a simple notice to the Board of Public Works, and they would acknowledge it and lift the debarment. So that's a good protection, but it also answers the timeline question. Secondly, if you're debarred under state law by the Board of Public Works for a state violation, the debarment lasts 5 years. And then the company can petition the Board of Public Works to lift the debarment. And at that point, it's still in the discretion of the board, but that time frame is also in current law, and this would be treated the same. So the other thing that this bill does, since it now mirrors existing law, if an agency were to say that a company violated a wage and hour provision or an equal pay provision, you'd have a contested case proceeding in front of that commission at that time, which kind of really sets the determination of whether or not you've done something wrong. And you have the right to appeal that agency determination of wrongdoing, including to a circuit court. After that whole process is final, if the Attorney General institutes debarment proceedings in front of the Board of Public Works, the Board of Public Works would likely, and in most cases, refer that matter, as counsel suggested, to the Office of Administrative Hearings. The company would then get a full adjudicated administrative proceeding in front of the Office of Administrative Hearings. That decision by the Office of Administrative Hearings then goes to the Board of Public Works for a final action on whether or not to debar or not. If the Board of Public Works debars the company, then you get to appeal that decision of debarment to the circuit court, which then provides you that kind of last and final level of review. So because the bill was changed to live within the existing provisions, all those protections, in our view, provide for a more fair process, and also a process that gives you as much protection from a due process perspective as you should have. So with those changes and the amendments, and we thank the sponsors' work on it, we would remove any objections to the bill as it stands. And it's up to the subcommittee to decide whether or not to move it forward. Thank you.
Thank you. Delegate Hill.
I'd like to move the amendment.
Okay.
Second,
As part of the debate, could I ask Delegate Saliga, you mentioned you still had problems with the bill. Are there amendments? I know there's a motion on the floor before us to deal with the amendment, but is there a specific addition or delete? Is there still a specific amendment that you wish to have us consider?
Thank you, Delegate Rosenberg, for your consideration of my concerns. And I will say that Mike Johansson answered them all. You know, I had some very specific concerns and finally got around to Mr. Johansson, and it, you know,
Okay.
it sounds like the adjudication, the due process is there, you know, the limitations are there, the, you know, protections are there for some kind of false accusations, yet, you know, the ability for our state to debar a company that's engaged in, you know, clear discriminatory practices is there as well. So after he answered all, you know, the questions I had, no, I'm fine with the bill. Thanks.
Okay, thank you. That was helpful. So the motion is on the amendments. All those in favor of the amendments, please say aye.
Aye.
All those opposed? It is unanimous. Is there a motion on the bill as amended?
so moved.
No, second.
Moved and seconded. Now, is our procedure that people are literally going to raise their hands? Is that what's
We've
being
just been doing a raise your hand if you're opposed. I think that's a bit easier for everyone.
fine? Anyone who is opposed to the bill as amended, please raise your hand. Seeing no such hands, the bill as amended is a favorable unanimous. Thank you to all concerned. Thank you. House Bill 182. Council, Lindsay, can you explain what the bill would do?
This bill requires the Maryland Department of Transportation by December 1st, 2022, and annually thereafter to compile and manage a list of certified lesbian, gay, bisexual, transgender, or queer businesses in the state to identify and encourage outreach to LGBTQ businesses and to track their participation in state contracts. There's no specific amendment offered on this bill, but I will note that the Department of Transportation submitted a letter of information as a written testimony on the bill, suggesting that it might make more sense for the Governor's Office of Small Women Minority Business Affairs to track this the LGBTQ businesses instead. Subsequent to that, to the bill hearing on this, GOSBA submitted a letter saying that they didn't have the software to do the tracking, that DGS builds out that software, and there might need to be some changes on it. So we're sort of left with a choice for the subcommittee if the subcommittee chooses to move forward on the bill between MDOT and GOSBA as to who would actually be responsible for doing this. The sponsor of the bill could not be here today, but she said she generally defers to the subcommittee on the subcommittee's wisdom as far as what to do, and would also be open to pushing back the effective date of the bill if it's necessary to build out the appropriate system to do the tracking of information.
Do we have any third party, the potential to get any third party advice as to whether such additional software is needed?
I don't think so. I will note that the fiscal note was written with MDOT in mind and thought that MDOT could handle it with existing resources.
Mr. Lovitz?
Good afternoon, Mr. Chairman, or Gosh, it's still morning already. Hello, everyone. Thank you. I'm happy to offer any kind of third-party support as the person who helped implement this in 20 other cities and states around the country over the last couple of years. I think it is an important point about the couple of links that I dropped in the chat just for everyone's information. A parallel example of this, of the implementation that Massachusetts implemented last year, adding LGBT, adding the checkbox, which is similar to the existing Maryland portal, and also the same way the Maryland Public Service Commission added an LGBT checkbox just to allow for data collection. So the process is seamless and it doesn't actually need a software update. We've had a few conversations with a few folks at the governor's office about how we can assist to do that and how we can help demonstrate parity with the other states that do this. And also to reiterate that it's not going to alter in any way any existing procurement goals or set-asides or waiting for any other communities, but this builds a parallel data set of the LGBT community that rectifies the disparities throughout Maryland on access to capital and access to information by allowing people to opt in and self-ID. It's going to tell Maryland where those deficiencies are so that in future study, as we look towards potentially adding goals in the state, this is the data set you'll need, but it also lets people get right to work helping particularly intersectional communities, LGBTQ people of color, LGBTQ women, et cetera, who are often displaced in their own business communities, finally have access to a lot of the state economic development programs beyond contracting, the education pieces, the capital pieces, the things that particularly the governor's office of small minority business covers, but has not had a direct pathway to engage this community.
But we have the Department of Transportation has not said it needs additional software to do this. Is that correct? Whereas GOSPA says, oh, we need additional software.
So if they were actually tagging, yeah, that's correct. So neither one actually would. So to simplify, neither would need new software. The misconception over at the governor's office was if this is being tied to specific contract goal, contract applications and that sort of thing, the systems weren't built to talk to each other. But identical to the Massachusetts example I sent you there, that looks just like the governor's office database now, and that would not need new software as the NGLCC and our partners turn over all of the data to the state and work with them on whatever's needed to tag it correctly and add that checkbox. But it costs there, it's completely revenue neutral. There are no new costs and no new software or staffing needed for it because their system's already built to handle adding a new box. It's an identical portal that we've seen in other states.
Okay, but the department has not requested, MDOT has not requested the additional software.
Correct.
Delegate Chisholm followed by Delegate Kaiser.
Thank you, Mr. Chairman. I'm just a point of information from Mr. Lovitz.
Yes, sir.
Wouldn't you, being the National Chamber, already have compiled all this information, and couldn't you just provide it to the state of Maryland?
That's exactly what we want to do. Great question, because that's what, and the bill, I believe it was in the fiscal note, it might actually be in that bill language itself. The NGLCC will be an official state partner. We are the state, we are the government partner on LGBT certification everywhere in the country, including up to federal agencies that use it. So that's exactly what we would do. At absolutely no cost, we'll turn over all of our Maryland data to the state, do it quarterly, by semi-annually, whatever is the preference, and then you have it. It's that easy. And a case in point with Massachusetts, for example, they went from having 14 self-identified LGBT businesses in their portal to 240 in one afternoon. So yes, we're ready to go.
Okay, so I'm a little confused on this. All you want them to do is add this check mark, but you're going to be able to provide them with the information, but going forward, you want them to continue part of what the process that you're already going through of compiling all this information and data.
Correct. So we want to be the partner that the government can, the Maryland sectors can rely on in the same way the PSC comes to us every quarter and says, do you have any new utilities or construction related suppliers to add to our database? We export and send to them. We can be that verification partner, and we can also offer our template for certification standards so the state can use it in the same way that Massachusetts, New Jersey, New York, a few other places utilize us to do it for them, but also saying, hey, we've got someone who might be a good fit. The Maryland LGBT Chamber, our local affiliate, unfortunately couldn't be on today, but they do this work, boots on the ground, finding, organizing, and they work hand in hand, I think most importantly, with the other minority supplier diversity groups in the state, the NMSDC, the We Bank, those that certify women, people of color, et cetera. There's already strong partnerships there to help find more people who identify in multiple communities, get them engaged in state programs. And by us turning over all that data to you, it keeps it completely free and turnkey, ready to go.
Okay, thank you, Mr. Chair. Thank you, Mr. Lovett.
Thank you, sir.
There are no other virtual hands raised. Oh, I'm sorry. Delegate Zaliga, followed by, oh no, Delegate Zaliga.
Thank you. Do we have this same system set up for women-owned business?
Yes.
Do we have a chain? I'm asking Lindsay or
Okay.
Women,
Alcard. Do
sorry.
we have a chamber that is a conduit for WBEs?
Women-owned businesses are certified by MDOT under the state's MBE program. So that
Okay.
is a little bit different than what the process would be under this bill.
So I guess I'm confused as to why we need this bill. If the LGBTQ chamber is already doing this, I mean, it sounds like the eventuality is that they want to get access to MBE participation. Is that where this is going? That it will, I'm just confused as to why we need this bill. If the chamber's already doing it, why does it, and I've been contacted by a couple of LGBTQ owned businesses, and they said, blah, 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 let me read it to you. There are already online resources, the LGBTQ Chamber, purpleroofs.com, gaycities.com, to name a few online resources that the LGBTQ community can find, LGBTQ owned businesses, and they do not feel underrepresented. So, and then they're concerned about not the LGBTQ businesses that would, not want to participate. How would that affect them? So just not quite seeing the need for the bill. So those are my concerns.
One additional element to what Lindsay said. Yes, the MDOT oversees the women and minority component, but already has a precedent that mirrors this for existing third-party certifications, such as We Bank that certifies women, NMSDC that certifies African-American, Hispanic businesses, et cetera, can be used to demonstrate, you've met all the requirements that Maryland asked for. It's a fast track, a pass through, depending. And so this is a parallel to that for the LGBT community because there is no public sector version of this. The need for it exists because we are not listed. We are not at the table and people are not participating. You are losing out on goods and services in the state because people do not see their name on the table. We're all talking about that table of opportunity, but we don't have a seat at it, let alone a name card saying, sit here. It's particularly true for LGBTQ people of color who are often removed from opportunities within their own networks and chambers. The reason also why this is needed is parity. We are going to have this instituted across the federal government through the help of the Biden administration, probably within the next year, but it's still going to require every state to implement identical policies that say on state and local contracts, we want to see more participation. It won't change weights, it won't change goals, it will increase the number of businesses who open in Maryland, participate in Maryland, and they'll only be included in that database if they opt in. So it's been incredibly beneficial for businesses to participate all over the country. And certainly we're already seeing the benefits of it, of construction-based LGBT BEs working with the PSC to literally build new infrastructure in Maryland.
Anything further, Delegate? Okay. Is there a motion on the bill?
Sandy, I was invited. When do I talk?
You, please, Vince, go ahead.
All right, thank you. I apologize. I was waiting patiently. Y'all are going right to the vote. I sent some of you some information recently. Because we're talking here about barbers, I'm sorry, about a certain group that supposedly doesn't have a spot at the table. I don't think that's true at all. As Delegate Jalega just affirmed, and we know this the closer you get to DC, that's absolutely not the case. And I can tell you Baltimore, again, absolutely not the case. I'm going to try and keep these comments to less than 4 minutes.
Make it
but-
less than 2 minutes, please.
Less than 2 minutes it is. Thank you, Sam. But there's no one that's organizing barbers to sit at the table, Christian model train builders or weave haircutters and stylists. This bill was offered last year. It was offered as a lie. The rebuttable presumption that was on it was caught in a lie and it's removed this year. But the essence of the bill surrounds the construct of lies. I want to point to the dishonesty of it. Now, I want to highlight that just yesterday in testimony in judiciary, HB 453, some women came in opposition to this bill, an abomination of a bill by Leslie Lopez, putting transgenders with women in women prisons. And it goes to speak to the vagueness versus the objective reality. And that's what is at the essence of this bill. Who's claiming that they're what? And how are you going to test it? I mean, this is about sex. And for this to be lost on this issue is the real problem. The state, it is above the state, their onus, and it is below the state's dignity to be affirming people based on how they have sex and with whom. And some of the details that I sent you at links, I'm going to have to rush through this because I got 2 minutes. Okay, but I sent you these links where just since you all last met in 2021, there has been a huge influx, whether it's Loudoun County, whether it's Washington Post talking about kink in front of kids, where this group is pushing to groom, indoctrinate, and other things to our children.
Can you
This should
please
not-
speak to this bill?
Yeah, so yes, I'm talking about a group that is open-ended, that you cannot define, that is increasingly aiming at children. And those people should not be validated by the state. That's what this bill would do. If they want a list, as I said when I gave testimony the other day, they can make that list. The man's telling you the list already exists, so pass the list around. You want to do business, you got the list. The state
Thank you
should
very
not be
much.
affirming this.
Delegate Kaiser, Delegate Kaiser.
Thank you, Mr. Chairman. And I was listening really clearly, and I think we all know that was just said by Mr. McAvoy. LGBTQ is not just about sex. That's just the most.
I'll send you the links.
Sir, it's just the most appalling and insulting comment that could be made and totally irrelevant to this bill. Lindsay provided all of us the documentation for what it takes to be an MBE. And that's not what we're doing here. But if you look at that part of statute, it's about underrepresented groups that were previously discriminated against. And that's why women were included. And I've heard Delegate Shalega mention the fact that she is a woman-owned business. And so women and minority-owned businesses have certain preferences for a reason. This bill isn't about preferences at all. And when you start talking about grooming and indoctrinating, you're really just demonstrating your own fear for difference. And there's nothing wrong with lesbian, gay, bisexual, or transgender people like myself. And to have people still saying that in the year 2022 is just so incredibly ugly. We're talking about businesses here. There are still LGBTQ plus people in this state who fear saying who they are. And this is a chance in some cases for them to put that information out there. And I can't believe we are still having to be subjected to such hateful comments. And I'm not at all referring to anything that Delegate Shalega said. I thought her concerns about the bill were legitimate concerns, but really just a response to Mr. McAvoy. Thank you, Mr. Chairman.
Thank you, Delegate. We share your concerns. Absolutely. Is there a motion on the bill?
Motion to
Bill.
approve the bill.
That motion is made and seconded. Is there any further debate by the members of the subcommittee on the bill? Okay, will those oppose? Well, let's do both on this. Those in favor of the bill, please raise your hand. Either, well, let's see. Yeah, let's do it. Raise your hand electronically, please. I feel a little more comfortable with that. So there are 1, 2, 3, 4, 5, 6, 7, 8. 8 in favor. Is that correct, council?
Yep, that's my count.
Okay. If you will take your hands down, please. Those opposed to the bill, please raise your hand electronically. Delegate Kaiser, I believe you wish, yes, okay. 3 opposed. Correct, council?
Yes.
3 opposed. Okay, the bill moves forward unamended, 8-3. Thank you. House Bill 235. Council, could you explain the bill?
Sure. This bill was discussed last week. The bill alters the definition of administrative function as it applies to Maryland's Open Meetings Act to exclude the appointment, employment, assignment, promotion, discipline, demotion, compensation, removal, resignation, or performance evaluation of an appointee, employee, or official over whom the public body has direct jurisdiction. Therefore, these matters do not fall under the Open Meetings Act's administrative function exclusion. In order for a public body to discuss these matters outside of an open meeting, the public body must close a meeting in accordance with existing Open Meetings Act procedures for closed sessions.
Okay, so if I may, just so I'm clear, because this bill is a negative of a negative, so it's difficult to understand perhaps. Under this bill, an agency, if it wished to close the meeting, would have to affirmatively vote to close the meeting to take action in this circumstance. Is that correct?
Yes. So let's say you want to give the executive director of your public body a raise, but you want to discuss how much that raise should be or something like that. The public body would have an open meeting. They would post an agenda of the open meeting. If the only item on the agenda is to close the meeting for this purpose, that's still listed on the agenda that there would be that they expect to have a vote to close. They would have to begin the open meeting, vote to close, cite the reason that they're going to close the meeting, which would be this reason for the employment discussion or the raise discussion, and then vote to close the meeting. They would record the vote of the closing, and then they would have to fill out the closing statement, which would be subject to inspection under the Public Information Act. And then they would go into closed session, which would be out of the public view to have their discussions.
Delegate Hill.
Yeah, so I guess this question is for the sponsor. So my understanding is a little bit different, which is that essentially under this bill, nothing would change except that in going into closed session, the public body would have to say it's for personnel reasons, as opposed to saying we're going to closed session for administrative reasons. That it's the qualification of the closed session that changes, not the ability to close a session. Am I wrong or correct?
Thank you, Delegate, for that great question. My understanding is that under current law, if a public body wants to meet in private to discuss giving a bonus or a golden parachute to their executive director, they don't have to go into closed session. They don't have to reveal to the public that a meeting like that took place. They can simply meet in secret and there would be no record of it whatsoever. So under this bill, there would be a record of such a meeting because they would have to take that action in a closed session. So there would be a paper trail of, that a meeting took place, when the meeting took place, where the meeting took place, and that it was, for the purpose of discussing a personnel matter. So it just, clears up a gray area that's existed in the act for many years. That's, identified in a report from 15 years ago in the Open Meetings Act manual, in many, many opinions of the Compliance Board. And most public bodies do this anyway because it's the best practice. And so this bill simply codifies that best practice for more transparency and openness. And I guess the question for the subcommittee is, do you agree that the bill is needed or not? There are no amendments. And, I feel the bill is needed, but it's really up to you as a subcommittee.
So let me ask this, so the objections, both from the board and from MML, is that, as I'm, again, trying to understand this, is they're saying that the way this is written, it is such a broad application that even a discussion about who we're going to interview, how we're going to fill a job vacancy, suddenly will require agenda being posted. They'd actually have to have a meeting over things that typically are not, and I guess that question is for Lindsay. Those are their objections. How do you read the current law and this bill with respect to their statements of this would, what I just talked about?
Is that a question for me or for
That's
Lindsay?
for Lindsay.
I don't know if I can speak to whether or not it is, if the bill is written overly broadly. I think that the idea is that these meetings for this purpose would be subject to the Open Meetings Act under the bill. And so the meeting would have to have the notice and all of the openness that I just described. As far as how many meetings might end up falling under this, I can't speak to how many meetings are out there of public bodies that would fall under this category. So I can't speak to the breadth of the number of meetings that would be impacted by the bill.
Okay, and then to the sponsor, the same question. You read the objections. I'd just like to hear your answer to the objections.
Yeah, so it's hard for me to, I don't speak for the board, but I think their argument was,
MML also, right?
So the board's argument was the bill is not needed. It won't result in more transparency. It might create more work for the public bodies and for the board. And I would respond to say, yes, it does create more transparency because it does create that paper trail, that a meeting occurred, it's public, because under current law, there is no paper trail, there's no public record created. And that can happen in secret. So I don't agree that it would create more of a burden for the board or for the public bodies, because most public bodies already do this because it's just a best practice. It avoids the appearance of secrecy. So for MML, I think their argument was, this might be awkward for a small municipality. What if the person who's taking the minutes is the subject of the personnel?
If I can, let me just read what they wrote.
Yeah.
So we can, certain matters may require conversation between regularly scheduled public meetings. For example, this bill would require them to post a public notice, open and close the meeting, and have their attorney or clerk present for the minutes to just hold an interview or discuss the discipline of an employee. And I have no basis to know whether that's a hyperbolic statement or correct. That's their argument, that even routine things would have to suddenly require a public meeting to be closed, or will require a public meeting for the purpose of closing it to set up an interview or do an interview, et cetera, et cetera.
Right. So, a lot of public bodies do meet regularly. So, there is the option to incorporate this into one of their, regular monthly meetings or whenever they meet. And there are provisions in the act to meet on an emergency basis. And I think most public bodies already do this, even if they're tiny municipalities or large municipalities, just because it's the right thing to do. Like I was looking at the website of a tiny municipality called Cottage City last night. They have a meeting tonight. I looked at their agenda. They have a closed session and it's on a personnel matter. So they did it the right way, which is to just have a closed session, declare it so that their citizens are, there's no impression of secrecy. Their citizens are aware that this is taking place. I don't know that their attorney has to be there or not. But I just, as a former municipal official in a small municipality, I don't agree that this would be, burdensome or awkward for a public body of any size.
All right, thank you.
Delegate Chisholm, followed by Delegate Kaiser.
Thank you, Mr. Chair. I'm looking more at the discipline side and the evaluations. Now, I operate in the private sector, obviously not the public sector. And it seems to me we could accidentally risk exposing somebody and leading to speculation. And what I mean by that is, in the private sector, and I own a business and I've always, when you're going through evaluations, you're constantly doing it. And sometimes discipline requires a quick reaction. It might just be small. I don't know how much benefit this really has to the public. And I know the public's not going to be aware of what the evaluation was or what the discipline was. But if they know that there was this public meeting and it was over discipline, and then the next day somebody gets let go, they may have just left, but now the public has the ability to speculate about somebody. I just don't understand where the real benefit of putting all of these different agencies in the position that they're going to have to document every single one of these things, knowing that they're already, most people understand that you're already going through these compensation discussions, these discipline discussions, these evaluation discussions, and it just doesn't, to me, it just doesn't serve the public good. They don't really gain anything by it. It's just a tremendous burden on many of these municipalities and these government agencies. And I'm just saying, I know it would put a tremendous, to have to go through the minutes and document all this is a tremendous task to take on for businesses and for these agencies, I'm sure. It's just my thought on it, just by the way I read the bill.
Delegate Kaiser, followed by Delegate Kipke.
Thank you, Mr. Chairman. I share some of the concerns that have been mentioned, not necessarily the documentation concern that was just brought up. I have a question and then a concern. Is this executive level only, or would this be for anybody potentially under discipline or golden parachute or being fired or whatever else? So that's a question.
Thank you,
This is oh, sorry.
Sorry, did you want me to answer or did you want Lindsay?
Whoever can answer it.
Okay, I'll start and Lindsay can correct me if I misspeak. So as written, the bill only applies to people who report directly to the public body. So for example, if it's a school board, it would be the superintendent. If it's a housing agency, it's the executive director. If it's a municipality, maybe it's the town manager, but it's not every employee. It is just certain employees, a small number of employees that would report directly to the public body as a whole.
Okay, and then my next comment, I think, really follows on Delegate Hill and Delegate Chisholm. I appreciate the wanting to know, but I'm still trying to understand how it's helpful to know that a given agency met in executive session or closed session last night to give, as you said earlier, as an example, Delegate Carr, some high-level executive a big payout before they leave. How is it good to know? How is it useful to know the meeting happened if we don't actually know who got how much? Why? How is it then helpful?
Thank you, Delegate, for that question. So under current law, there's no way to know, what happened. There's no track record. So unless you're looking at the, budget line item and you see something tick up in terms of the compensation, there might have been a very controversial payout or bonus or increase or golden parachute awarded, but, there would be nothing to trigger any scrutiny of that. And with this bill, there is a paper trail that would provide some insights that something like
What's
that
on,
took place.
what's on that paper trail? Simply that there was a meeting about someone's pay?
Yeah, the public body met in closed session to discuss a personnel matter. If they may have to mention the topic, it was the performance of the executive director, compensation of the superintendent,
Okay.
performance objectives, generic.
Thank you.
Delegate Kipke, sorry.
Thank you, Mr. Chairman. Al, I'm going to start calling you the Sunshine Man, bringing all kinds of sunshine. To be clear, isn't it under this bill only required that it would say to meet for a personnel matter?
Yes, under this bill, it says if you meet for a personnel matter, you meet in closed session, you don't invoke the administrative function, which requires no disclosure.
It really doesn't. My problem, respectfully, is it just doesn't provide much. And for Anne Arundel County, for example, they're a big county. They've got a lot of staff, and they can do that. But to put on paper that they met for legal advice, it doesn't tell you what the legal advice was for. And so I just feel like there should be some discretion here for the smaller jurisdictions, in my opinion. And I was thinking about, I'm on the ethics committee, which is my favorite committee, by the way. But
More so than this subcommittee? Both serve on the ethics committee.
Definitely, Sandy, and it's your favorite too. But we'd have a list of personnel matter, it's just I don't know what we're achieving with this that's of any real benefit to the public. And I say that respectfully, Al, and you're batting 95% this year anyway, so you're doing pretty good. But anyway, but I just want to throw that out there. I think we should allow that discretion. Let the personality of each jurisdiction make that decision for themselves. Unless we were going to dramatically change what needed to be put on the form with more detail. Maybe there's a reason to have a conversation like that, but I'm still stuck in the place where I just don't think this is necessary. And of course, there's still opposition out there, and we have a culture of really trying to work it out with individuals and trying to come up with something that is more of a consensus product. So anyway, with that, so Al, I love you, man, but I can't vote for this one at this point. Maybe some other time we can work it out and get somewhere else. But that's it. Thanks, Mr. Chairman.
Thank you, Delegate Kipke. Council, are you satisfied with direct jurisdiction would be interpreted as the sponsor, Delegate Carr, has described it? Do you think that adequately defines? He was saying it's really the top person in an agency.
Yeah, I do think that adequately captures the way the sponsor intended it to, not to mention our discussion on it provides some legislative history on how that intent was meant to be interpreted as well.
Okay. And the legislation that we passed last year, sponsored by, I believe, by Delegate Foreman in response to the environmental entity. Do you know how it deals with this issue, if at all, or is that something you'd have to research?
I would have to look into that.
Okay. I would like to put off a vote at this time and
Get my fucking hand up.
get a setter get a better sense of where the committee is as well. Although I will take further conversation, further discussion, Delegate Young, followed by Delegate Landis.
Thank you, Mr. Chair. Just want to offer a little bit of perspective. Our delegation has fairly recently had two very public conversations about salary increases. For the last couple of weeks, we have debated an increase to the sheriff's salary very publicly. And a few years ago, we discussed and approved the state's attorney's salary. It is so transparent that it is uncomfortable, but we've got to do what we've got to do. I think this bill is a nice compromise, and I hear the point of what's the point in just saying it's on the agenda if you're not then going the next step and saying what it is. But I do agree that it offers some level of transparency that at least the public knows the topic is being discussed, while protecting a more in-depth conversation that can sometimes be very awkward. So just wanted to share that perspective.
Thank you, Delegate Young. Thank you. Delegate Landis. You don't wish to speak? Okay. Well,
I am so sorry. I was on mute. I'm so sorry. I just wanted to share with the fact that in my previous life prior to coming here, and I retired from Prince George's County Public Schools. I worked for the Board of Education for 17 years. And all of our meetings was before we could go. It was always on the agenda, but before we went back in executive session, we did have to announce that we were going back in executive session for the purpose of maybe dealing with personnel matters or contracts or whatever it may be. It became an automatic part of the process that I implemented as the board's executive administrative officer to do that type of notification. I've always supported it because it does provide, in fact, transparency of process so that the public will know what's going to be discussed. And of course, and then after we came out of executive session, there was a brief announcement, that we didn't exactly say exactly what happened, but, that we did discuss certain items. So I'm very much in support of full disclosure for the public. And, but I'm also glad, Mr. Chair, that you're deferring this so that we can think about it a little bit more. Thank you.
okay. All right, Delegate Johnson.
Thank you, Mr. Chairman, and thank you, Delegate Carr, for bringing this. And again, I'm with Delegate Landis that I am 100% for transparency. But as we table this, I would like for us to talk about, because I really, by reading this bill, don't know still how specific or in-depth or detailed they have to be with the public. Is it generic a personnel matter or just exactly how involved they want the explanation to the public to be? So I would just like to understand that a little better as we table this and discuss it. So thank you, Mr. Chairman.
Thank you. Okay, so this bill has been tabled, and that concludes the work of the subcommittee. And the full committee meets at 1. Is that correct? For bill hearings? Or is it later hour?
I think it's 1:30. It's 1:30.
Okay, 1:30 for bill hearings, and we, as a subcommittee, stand adjourned. Thank you.
Thank you.